All right. Well, I don't know how many folks are there, but whether it's three or four people or 15 or 20, I appreciate everybody being here and being available to listen, and applaud you for wanting to take part in this abolition week and the conversations that are so important around the criminal legal system, this system of mass punishment that we have unfortunately built for ourselves, in which I think, just about everybody has been complicit over the past 50 or so years. Um, I will share a little bit about myself and my story and the role that I have played within that system and the work that I'm trying to do to resist that system. But I would really, really much rather people feel free to jump in and make comments and ask questions. I'm not really wedded to any particular notes or agenda, and I want to talk about what the folks there are interested in talking about. So feel free to interrupt me and let me know if there's comments or questions. I'll be happy to go down rabbit holes. But just to get started, I'm Preston Ship. I'm in Nashville, Tennessee, and I work for an organization called the Campaign for the Fair Sentencing of Youth. The campaign was started in 2009. It was founded by the most notable founder was Brian Stevenson of the Equal Justice Initiative, but there were a few others. And what was happening is this group of people, after the Roper versus Simmons case in 2005, in which the U.S. Supreme Court held that the death penalty could not constitutionally be applied to someone younger than 18, Brian and others recognized that life without the possibility of parole was sort of the next, I guess, obstacle to true justice being done for young people, because life without parole is essentially death by incarceration. You're telling someone who's 14, 15, 16, 17 years old that it doesn't matter what they do over the next 5 years or 10 years or 20 or 30 or 50, that there's nothing that they could do that could ever uh, demonstrate that they are redeemable, that there's no steps that they can take. There's no opportunity for a second chance. There's no hope of life outside prison. Nobody's ever going to look at them again. They're just going to grow old and die in prison, which is extraordinarily harsh. When you think about someone who's 15, 16, 17 receiving that sentence, which is so much more punitive than receiving that sentence when you're 30 or 40 or 50 years old, because a 50-year-old serving life without parole is only going to live, 20 years, 30 years in prison, whereas a 17-year-old could live 60 years in prison. So Brian and others founded the Campaign for the Fair Sentencing of Youth, and that little ragtag group of people got to work trying to abolish life without the possibility of parole as a sentencing option for children. I was not there in the early days of the CFSY. I come to this work from the total opposite perspective. I was not an advocate for criminal legal reform, certainly not for abolition. I went to law school here in Tennessee to become a prosecutor. I was raised very conservative, and as a very conservative, religious white person, I tended to believe that the criminal legal system was working like a charm, because victims need to be vindicated. We need public safety. We need somebody to wear the white hat and put the bad guys away. And I was convinced that that was the role that I needed to play. I had interned with the local county prosecutor's office here in Nashville when I was an undergrad. That was really my first exposure to the legal system. And I was, utterly, I found the role of the prosecutor completely compelling, because they were running the show. They were the ones who were giving instruction to law enforcement officers about pending investigations. During hearings, they were interrogating witnesses. They were conducting plea negotiations with defense attorneys and announcing those agreements to the court. They were wearing their suits in high-profile cases. They were going in front of the news cameras, and they were talking about the need for justice to be done in order for our community to be safe and victims' rights to be upheld. And I just thought, well, that's just the work that I want to do. That's work that really matters. I care about justice, and I want to see justice done. And so I went to law school to become a prosecutor. Didn't give a rip really about any of the other classes. I took them because I had to for the bar exam, but didn't care about torts, contracts, business associations, tax. I was about criminal law. I was about criminal procedure. I was about trial practice and appellate advocacy and anything that I thought would make me a better prosecutor. That's what I was interested in. And after clerking for a judge for a couple of years, I went to work as a prosecutor in the Tennessee Attorney General's office and had no plans to ever do anything else. There were people there at the Attorney General's office who were career prosecutors. They had worked their way up through the ranks and were serving as deputy attorneys general. They were serving in the Solicitor General's office, and I just thought, well, that's it. That's my career. And what ended up changing things for me after I'd been with the AG's office for a number of years, and I was doing primarily appellate work. There was a little bit of trial work sprinkled in there, but for the most part, I was representing the state in appeals all over the state, all different kinds of cases, criminal cases. What changed for me and caused me to sort of rethink the role that I was playing within that system, because in law school, I was not trained to question the system. I was taught to plug into the system, which I think as law school students, that's really important. I was in school from 99 to 2002. So this has been a little while since I've been in school, and maybe law schools are doing a little bit better job of helping students, helping future lawyers think critically about how the system is working and even think critically about the legitimacy of the goals that the system allegedly tries to meet. But it didn't work that way for me. I was kind of like, it was like training to become a worker on an assembly line. You don't worry too much about, the assembly line worker is not asked to think much about the quality of the final product that rolls off the assembly line. They're just taught to tighten their little bolt and be the best bolt tightener that they can be. And if they don't feel good about that bolt anymore, they can leave and somebody else will come tighten the bolt. That's kind of the situation that I felt like I was in this very impersonal system. But I believed in the system. I think that most prosecutors believe that the system is working as it should. And there was nothing really happening to disavow me of that. The system is very impersonal, especially when you're doing appellate work. I did not have an occasion to meet with the defendants in my cases. For the most part, they had already been convicted and sentenced. And, when I had an oral argument, it was just me and the other lawyer and the panel of appellate judges. So there was not an occasion for me to get to know anybody or hear the larger context in which the crime occurred. It was just a cold trial record. I read the transcript. I read over all the pleadings, wrote my brief, made my argument, moved on to the next case. But still very invested in the idea that people who broke the law needed to be punished. So that started to change when the college that I attended started a college prison program. And the vision for that program was that they would take 15 traditional college undergrads out to the Tennessee prison for women, and they would have 15 of the people who lived at the prison enrolled in those college classes so that they would be, building a transcript and earning college credit. And the gentleman who developed that program and directed that program was one of my major professors, and he was my advisor. And he and I had stayed in touch just a little bit. He knew that I was a prosecutor in the Tennessee Attorney General's office, and so he invited me to come teach out at the Tennessee Prison for Women the very first class in this really really cool program. He wanted them to study judicial process together. He thought that would be a good class topic because half the class had been through the judicial process and half the class probably had no idea what the judicial process was. And so, bringing those two very different groups of people together to talk about judicial process was kind of his vision for how to start to that. It was called the LIFE program, which stood for Lipscomb Initiative for Education. And so I went out there, really geeked up about teaching a college class. I'd never taught a college class before, and it seemed very innovative and interesting. And even though I was a prosecutor, I wasn't some, heartless monster. I wanted people who went to prison to experience rehabilitation. And I knew how important education is to lowering the recidivism rate and stuff. So I didn't go out there, expecting to like hate anybody. I was glad. I was glad that Lipscomb University was offering them this opportunity and they were taking advantage of it. But at the same time, I was still a prosecutor going out there. I assumed that they deserved what they got, and they needed to serve their sentence because they had done something bad. They'd broken the law. But I was not prepared for what I found when I went out there. Um, I was not prepared for the effect that proximity, going back to Brian Stevenson in his book, Just Mercy, he talks about the power of proximity. And as long as we are able to maintain distance from one another, certainly from people who are dehumanized, demonized, whether you're talking about people who are incarcerated or people who immigrate here from other countries or people of other religious faiths, as soon as you have that distance, that's what enables you to consider them as somehow different, less than, to other them, to scapegoat them. We see it with people who are incarcerated all the time. The dehumanizing language that's used about them, that's only comfortable for us because we're not proximate to them. So this was my first opportunity to be proximate, to be in the same room with people who were locked up that was not a courtroom, and even in the courtroom, they often, as I said, were not present. But we got into that prison classroom, we put our chairs in a circle, and we were just people, nobody was talking about their crime. They knew that I was a prosecutor, but didn't seem to hold that against me. I think if anything, they thought, well, here's an opportunity to learn from somebody who uh, knows what he's talking about, and I think that they were sort of thinking about that I might be able to kind of give them some pointers for litigating their appeals because that's what I did all day, every day. Um, so I didn't feel any real animosity. Um, but what I heard from them as we continued to share and get more comfortable with one another and that proximity started to work on me, I was impacted by just what a profoundly gifted, um, just remarkably good group of people it was. And some of them were serving life without the possibility of parole for being involved in a homicide offense. But they were, again, invoking the language of Brian Stevenson, they were all more than the worst thing they had ever done. They had all invested so heavily in their own rehabilitation. Here they were in a maximum security prison, enrolled as college students and excelling. They were knocking the top out. The traditional college kids were not able to perform at the same level as the inside students, as we call them. And several of them maintained 4.0 averages throughout the program. I was so proud of them. I would have been happy to write any of them a letter of recommendation. I'd be happy to testify in support of them if they came up for parole. I started thinking of them as friends. Um, and that is a weird position for a prosecutor to be in because as I said, prosecutors, they need that distance. Um, all lawyers, we're taught that we have to remain emotionally distant in all of our cases. Even if you're a defense attorney, we need to maintain that professional distance. And for prosecutors, that professional distance is largely consists of blinders, where I can't see the full human context in which this crime committed. I'm insulated. We have the rules of evidence where we exclude information that is deemed irrelevant. Um, And so there's a lot of details that juries never hear, and there's lots of details about the human context in which these crimes are committed that even the judge and the prosecutor aren't privy to. And I was hearing about this firsthand. I was hearing about, how so many of these crimes, especially violent crimes, exist in sort of a perfect storm. So often, there was prior abuse and trauma and neglect at the root of these crimes. That the people who committed the crimes were themselves victims of violence, and that often that caused mental health issues. If you're abused, if you're victimized, you can develop post-traumatic stress disorder and depression and all sorts of other issues. And if you're poor, and don't have access to mental health services, then you self-medicate, and you do that, with not a doctor's prescription, but something that you can buy on the street, and now you've committed a crime. And so, it's like this terrible, vicious downward spiral into criminality. None of those people were just autonomous in a vacuum and they just decided to break the law. All of them, as they shared their stories, I was hearing these common themes, and over again, I was thinking to myself, if I were in that situation, I can't say that I would have acted any differently, which again, that's a hard position for a prosecutor to be in. This all came to a head. I was feeling a great deal of angst. I ultimately decided I could not continue on as a prosecutor. Because again, I was rooting for these folks, and I was wondering to myself, uh, if I had the opportunity to get to know personally some of the people whose cases I had actually worked on, the hundreds and hundreds of cases where I had written a brief, made an argument about the fate of someone I did not know. What if I had a chance to sit in a prison classroom with those people and hear their story? Would I all of a sudden consider them friends? Would I still feel comfortable arguing that they needed to spend 5 years in prison, or 10 or 15 or 20 or 25 or 30? Um, or would I be hoping that they got a second chance, and hoping that would be an opportunity for a parole board or someone to take a look at them down the line? Would I be more concerned with them getting help than I was with them being punished? Because that's exactly how I felt about the people that I got to know through the prison program. So, those sorts of questions I think are largely foreign to the minds of prosecutors, because prosecutors are trained to think about a very small number of considerations, and to ask a very limited number of questions. What crime was committed? Who's responsible? What's the punishment going to be? Not how can we help this person? And I was feeling increasingly like, well, I want to help. I want to help people get the care that they need so that they can thrive. So I quit my job, and I thought that I had done everything that I needed to do, um, in order to kind of take care of my conscience, and feel like I was square with the friends that I had made through the prison program. But after a few months after I left my job, of course, I was doing appellate work, as I said, which is slow. You make an argument, you file a brief, and then you wait months for the appeals court to issue its decision. And so even after I left my job, I was continuing to receive opinions in the mail. And one came one day, to my mailbox, and I opened it up, and before I could really read the opinion to see what the court had done in the case, I recognized that the person was someone who was in the class that I was currently teaching. And I think that sort of demonstrates the impersonal nature of the system. That when I received my class roster, I never noticed that the person who was in my class was someone who months earlier was a case that I had worked on. You just don't think that you're ever going to meet those people face to face. The likelihood of one of my cases actually showing up in that little prison classroom was very, very slim, and I never even considered it. Um, but there it was in black and white, and her appeal was denied. She had killed a person and she was serving a 51-year life sentence. And I had argued before I even knew her that that conviction was proper and the sentence was appropriate under the law and that her appeal should be denied. And the Court of Criminal Appeals agreed with me. And I knew as soon as I, you know, kind of recovered from that realization that she was in my class, I knew she was going to receive her own copy of the opinion and that she was going to see that I had represented the state in arguing that her appeal needed to be denied, and that by the time our next class session rolled around, she would have read the opinion and known that I was the prosecutor in that case. And and if you're familiar at all, it's been a few years ago now, but if you're familiar with the name Centoya Brown here in Nashville, Tennessee, that was the person. Um, Centoya, her case achieved some notoriety several years ago. Um, Her case went viral, and people like Kim Kardashian and LeBron James and Rihanna and Ashley Judd and some others started sharing it on social media, asking why in the world would a 16-year-old child who was a victim of sex trafficking and who finally just lashed out when she felt threatened, why would she be convicted of first-degree murder and sentenced to life in prison? Um, and when I showed up to teach that next class, of course, I did not get a whole lot of sleep after receiving that opinion and wondering how Centoya was going to relate to me the next time we saw one another. I didn't know if I'd ever see her again. I thought she might drop out of the college program, and 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 she was such a gifted individual and so enthusiastic about being in college and loved reading and sharing what she was reading. And it was just devastating to think that I was going to have to confront um, in front of her, with her, the role that I'd played in her case. And again, had been counsel in many, many other cases very similar to hers. But this one, I was going to have to personally apologize for the role that I played in her case. And so that's what I did. When I got to the prison, she was waiting for me in the hallway outside our class, holding her copy of the opinion. And and she wanted to know when I knew. She was clearly hurt. She clearly felt betrayed, and she wanted to know when I knew. And I just profusely apologized and told her that it never connected in my mind that the Centoya Brown, who was this, beautiful, um, funny, talented person in my class, that was the same Centoya Denise Brown whose case I had reviewed. Her case record took up a banker's box. It was but it never connected, until I got that opinion. And I apologized, and she was very gracious. She was as gracious as she could be. She told me that, she understood that I was doing a job, um, that I had since quit that job because of the feelings that I was having and what I was learning from her and other people who were locked up. Um, but she told us, she said, we're gonna have to work on this relationship. We're not in a good spot. And so we did. We continued through the semester trying to sort of reconcile that we had been on opposite sides of that case. And we started corresponding via letter after our course concluded. And we're able to kind of put that back together. But she told me that, one of the things that I was going to do now that I had learned so much about how the system functions and how it treats vulnerable people as disposable, and it seeks really only to hurt, never to heal. She said that it's going to be very important for me to take what I had learned and to try to use it to help other people, especially other kids. And eventually, this led me to the Campaign for the Fair Sentencing of Youth, because I was becoming increasingly involved in criminal justice reform. especially for young people. And I was speaking and I was writing about it from the perspective of a former prosecutor. And so eventually the Campaign for the Fair Sentencing of Youth um, invited me to come lead their legislative advocacy work. And so what I do, what I do now as the associate policy director for the campaign is I go around the country and I meet with lawmakers and prosecutors and other stakeholders and try to help them understand the lesson that I learned, which is that it is not good policy to emphasize punishment over the promise that all people have, especially young people, of of transcending their worst moment and being so much more than this this bad thing in their past. And it's been a real joy and a gift to get to partner with so many other people like Centoya who have demonstrated, and she's out now, by the way. She through a remarkable turn of events, she received executive clemency from the former governor of Tennessee, so she ended up serving 15 years of that 51-year sentence, and she's now out and is a very effective advocate for other victims of trafficking and young kids who get caught up in the adult system. But there are so many people like her whose names have never been hashtags, but who are demonstrating just how much we stand to gain when we stop focusing on vengeance and stop pretending that justice is tantamount to punishment. There are so many folks who are home thanks to changes in the law like the ones that I advocate for, people who have been called terrible things, menace to society, super predator, worst of the worst, monster, um, been given some of the most harsh sentences available on planet Earth since the U.S. is the only country in the world known to condemn children to die in prison. Yet, when these changes in the law happen and people come home, they find the most creative, imaginative ways to serve their communities and make their communities stronger and safer. So I think about, I have a friend in Michigan whose name is James Thomas. They call him JMO. JMO was one of these people that when he was 16, he's the worst of the worst. He can't be redeemed. He can't be rehabilitated. And so they give him life without the possibility of parole. The law changes. He gets resentenced to a parolable sentence. He makes parole. He comes home and he was noticing he was living in a poor area of Detroit that has a lot of unhoused people. And so he made a practice of just having a few sack lunches with him everywhere he went so that he could share food with people who needed it. And people started hearing what JMO was doing. And so they would give him $5 here or there. They'd give him a loaf of bread or they'd buy some extra lunch meat when they went to the store to give to him to include in the lunches. And this little project started growing and growing. And JMO had to start a nonprofit to handle all of this. And now JMO is the executive director of an organization that feeds over 400 needy families a week. And this is the worst of the worst. There's nothing we can do for young JMO. Well, that was wrong. That was wrong. The system got that one wrong. And there are now over 1,100 people like JMO who were all given life without parole when they were children, who are home. And they are doing remarkably well. They have a recidivism rate of 1.14%. And it's not just JMO. We've got a guy who does violence intervention programming in Philadelphia. We have somebody here in Nashville who runs a restorative justice diversion program in juvenile court. We have someone in Chattanooga who's a substance abuse counselor. We have somebody in Seattle who's a reentry specialist, all of whom were given these crazy long sentences as kids. And that sort of brings me to, I think, where my experience and my work with the campaign intersect with the conversation around abolition. Because if you think about the work of an organization like the Campaign for the Fair Sentencing of Youth, trying to make sure that kids are not given the most extreme adult sentences, that there is room for review for second chances, for parole eligibility, whatever. That's very important. But if all of a sudden that work was done all over the country and all 50 states said, yes, we're going to stop throwing kids away. We're going to make sure that kids always have the hope of a second chance. That's sort of a drop in the bucket when you consider the immensity of our system of mass punishment. Um, there's so many other things that we could say the same thing about. If all of a sudden we treat drug addiction as a public health concern instead of a criminal justice concern, and we take all the money that we spend warehousing addicted people with substance abuse issues, and we pour that into education and treatment, so that we're no longer criminalizing people for possessing marijuana or cocaine or whatever. We're really going to treat it as a public health crisis. If we start funneling resources into mental health programming, so that the prison system is no longer the largest mental health provider in the country. If we stop criminalizing homelessness and poverty, those things are all so terribly important. But we are still operating we would still be operating within a system in which we believe that justice equals punishment. As long as we're relying upon punishment, prison, the intentional infliction of suffering as a response, if we're only seeking to address harm through the imposition of more harm, then we're not doing the real work. It may be important, it may be necessary, but the real work, I would say the work of abolition, is about a whole paradigm shift. Because right now, all of those things that I just mentioned, those different manifestations, that's what they are. They're manifestations of a larger spirit of institutionalized vengeance. There is this spirit of institutionalized vengeance that animates our society, nowhere more clearly than the criminal punishment system. But once you start seeing it, you notice that it's everywhere. You notice that in our state capitals and our courtrooms, and certainly in our prisons, that there is this cloud of vengeance that sort of colors the way we see everything. It's in the rhetoric that politicians use about people from other countries and people, in the LGBTQ community and people of other faiths. It's this spirit of vengeance. On the criminal court building in downtown Nashville, it says, the first duty of society is justice. The first duty of society is justice. But it does not define what justice is. And if you are not an abolitionist, then the temptation is to think, well, the first duty of society is punishment, which is absurd. That is absurd. That is not the first duty of society. Justice is not a euphemism for punishment, although that's how it gets tossed around in order to justify our punitive policies. Justice is about healing what has been damaged. It's about restoration. In the case of Cyntoia Brown, justice was not served by giving that child 51 years, even though she had killed a person. But what she needed, what justice required, was for us to expand the perimeter of our sense of concern and kinship to include this 16-year-old girl, and to ask, where did our society break down that this child found herself on the streets, homeless, addicted, and being victimized by a trafficker? What do we need to do to make sure that she gets what she needs to heal? And how do we need to strengthen our community so that we don't see this happen again? That's the first duty of society. And as long as we have this spirit of institutionalized vengeance hanging over our criminal justice policies, then we're going to have more Cyntoia Browns. We're going to be sending people to prison like JMO, like Cyntoia, like all of these people that I'm so fortunate to have gotten to know and to work with over the years, who were told, that they were no more than their worst deed or moment. Again, we've neglected the promise that all people have in favor of punishment. And that is why I think when we talk about abolition, when we talk about, well, I should say when we talk about reform, that what we really need to be talking about is abolition. Um, but I hope that when people hear abolition, that they have a more sophisticated and nuanced view than to think that it's just a matter of taking a hammer and chisel to all the prisons and just tearing them down. Because abolition is as much about working on people's hearts as it is working against the institutions that continue to perpetuate harm and cycles of violence. It's about a fundamental paradigm shift within larger society, yes, but that starts with people like me. You know, I had to go through sort of a little mini individualized paradigm shift, a little bit of abolition on the personal level to recognize I can't continue to just sit here and tighten this bolt day after day after day and pretend like I'm not responsible for the final product that's rolling off the assembly line and ruining people's lives and communities and making us less safe, not more. That's I think the work in front of us as people who are committed to criminal legal reform. We want to continue to argue that kids deserve second chances. We want to continue to argue against the criminalization of homelessness. We want to continue to fight against the war on drugs that has been so devastating over the past 50 years. But there needs to be up above that at the 30,000-foot view, we need to be thinking in terms of how are we changing our consciousness, our minds, our hearts, so that we're recognizing that this spirit of institutionalized vengeance is like the water that we're swimming in, and we need to be able to recognize it and articulate it for ourselves and for others and say that does not have to continue to be the way that we understand our obligations when harm is done. You know, that we can think in terms of repair, healing, compassion, restoration, not just in terms of more of compounding harm and suffering. So I think I've talked a lot longer than I really intended to, and I haven't heard anybody try to chime in. So let me stop and see if there are comments or suggestions or questions, because I really would love to hear what other folks are thinking.
I have a bunch, so if any of you have questions, I'll let you go first. Okay. Hello. So I work at the public defender's office here in Franklin County, Ohio. I love it. It's probably my favorite thing that I've ever done. And I write a lot of sentencing memos for adults obviously in the office. And two of the factors for sentencing felonies here in Franklin County and sentencing in general is whether or not that adult had been adjudicated delinquent as a child, and that's one factor. And then there's another factor that is whether or not they had been adequately rehabilitated as a delinquent child. What is your perspective or the campaign's perspective on using, the adjudication of delinquent children as a factor for sentencing as adults, and the view of how we continue to punish adults for crimes that they had committed as children, even though they're essentially completely different people on a developmental level, and whether or not there is a possibility for sentencing reform in that aspect for adults.
So to the second part of your question, yes, there is the possibility for reforming that. In fact, around the country, I guess not in Ohio, not that I'm paying super close attention to Ohio, because we passed a bill there in 2021, so it's a little bit off my radar. But we still have a good relationship with Jill Beeler and Charlene and stuff, if you know them with OPD. But there are bills around the country basically precluding sentencing courts from using juvenile adjudications as aggravating factors. And those bills are rooted in the science of adolescent brain development. You know, that if it's absurd that we would, in this one sphere of the law, pretend like children are the same as adults. Because, you know, someone who's under the age of 18, and I recognize there's nothing magic about the 18th birthday, but in every other sphere of the law, people under the age of 18 cannot vote because we don't trust them to make good decisions and be responsible and be educated and informed. We don't let them serve on juries for the same reason. We don't let them serve in the military. We don't let them get married. We don't let them sign contracts. Lord have mercy, we're not going to let a child enter into a binding contract because they don't understand the implications and the risks and the consequences of what they may be agreeing to. If they're under 16, we don't let them drive a car. If they're under 21, we don't let them drink alcohol. If they're under 25, we don't let them rent a car. Because we recognize in all those areas of law, we don't let them buy a lottery ticket. They're irresponsible. Their brains are not fully formed. The frontal lobe is not fully formed, and that's what helps you make responsible decisions. But if you're 16 or 17 and you kill somebody, we're going to pretend like you're the same as a 30-year-old. And it's because of the spirit of institutionalized vengeance that we think when something like that happens, when somebody gets raped or killed or robbed, well, somebody's got to pay. And even though it's somebody who's too young to make a good decision for contract purposes or serving in the military or on a jury or whatever, our spirit of institutionalized vengeance says that kid's got to pay the same as they would if they were a responsible adult. And so, you know, lawmakers around the country, thank goodness, some lawmakers are recognizing that that is a betrayal of what we know to be true about the brain development of kids. It's also a betrayal of this concern that we claim to have for kids, because everybody believes that children are the future. Everybody wants to be regarded as, you know, we care about kids. And so you want lawmakers to connect those dots and say, well, goodness, if you're talking about somebody who was 15 or 16, then and doesn't have a fully functioning brain, then no, we're not going to use some delinquency adjudication as an aggravating factor when they're an adult, because it's almost like a different person in terms of the way that their brain was working. I hope that we'll see more bills like that around the country, really making a distinction. That's why we have juvenile court. That's why we have, you know, a different system for kids. And so we shouldn't try to pretend that they're the same and use one and the other.
Also questions? Okay, good, because I have another one. I'm so sorry. I'm in a juvenile law class right now with Professor Brooke Burns from OPD. That's how I learned about you. We talked about that in the email. And I'm writing like a paper, and we're working on a podcast project right now. And my group is doing the experience of juvenile incarceration as like our overarching topic. And it's been really interesting to read about the amount of juvenile detention facilities and like the level of like maltreatment and abuse and violence that are instituted among these children. Do you have like any thoughts about how, like, is there a world in which we can prevent that? Or is that still rooted in like the institution of vengeance that you have talked about?
I think that it is rooted in that. I think that, you know, when in the 90s, when we started talking about children using the word super predator, that's a really helpful word for understanding and articulating where our hearts and minds are with respect to these kids. That we felt comfortable talking about children that way. I think that shows the degree to which we are all in need of sort of a collective exorcism in the way that we think about, especially children who cause harm. And if that's how you're thinking about people like Centoya Brown or JMO when he went in, if you're thinking that these are monsters, these are super predators, irreparably corrupt is one of the language, some of the language from a Supreme Court case dealing with the issue, then they're getting no worse than what they deserve. If a police officer or a guard abuses one of them, well, it's no worse than what they deserve. Look what they did, you know. Again, it's an altogether different paradigm from the one that you have when there is some proximity there. I had a meeting. Put a story with it, a little anecdote here. I had a meeting with a lawmaker in Arizona earlier this year, and we were talking about this issue, specifically kids who cause harm. And he said, I can almost quote it verbatim. He said, "Well, I'm a Christian, and so I do believe in redemption and forgiveness. But," he said, "I'm also a father, and I know that if someone ever hurt one of my children, that I would never, ever forgive them." And I thought, well, it's really interesting the way he framed that up. We're here talking about children who cause harm, and where his mind goes is, what if one of his children were harmed? He did not say what his response would be if one of his children caused harm. And that's the disconnect that we're going to have to overcome. When we're talking about throwing children away or not concerning ourselves too much if their rights are violated or they're subjected to violence and abuse in juvenile facilities or adult facilities. We've got to get past the point where we think, well, that kid's not like me or my kids at all. I've got all the distance in the world from this problem because I would never do that and my kids would never do that. And if anybody ever did that to one of my kids, I would be out for vengeance. And instead, we have to overcome that disconnect and say, well, how would you feel if your kid caused harm? Would you want us to give up on them? Because some of these folks that I work with and partner with in these states, they didn't hurt anybody at all. They might have driven a car and somebody gets out of the car and goes into a house and somebody ends up getting killed and they come back out to the car and they drive off. And next thing you know, the driver of the car is serving life without the possibility of parole for felony murder. Or they may have gone to stand lookout while the buddy was going to swipe a case of beer, and they didn't know that their buddy had a gun, and they hear the gun go off, and they go inside and they see the store clerk bleeding out, and they're still standing there looking at him when the cops arrive. The cops say, "What happened?" They just blurt the whole thing out, and next thing you know, they're being threatened with life without the possibility of parole. Those kids had parents, you know, and you've got to be able to think, well, what if it was somebody that I cared about? You've got to be able to overcome the disconnect and think, in a more empathetic way about, well, what if this happened to somebody that I loved? How would I want them to be treated? That's honestly, I'm 100% being honest. That's how we need to make policy decisions. Is, well, what if this was somebody that I cared about?
Anybody else think of anything? It's okay if you don't. Because I have one. I also am in this in a juvenile law class, so I'm thinking about this stuff all the time. My last question is very broad, so feel free to take it wherever you think is appropriate. But I've been doing a lot of reading about the school to prison pipeline, and the correlations that we see in schools and educational facilities, and how you had already mentioned that education is one of those really important things that will lower recidivism rates. But how in disproportionate communities do we hit the children who aren't being adjudicated delinquent but are at high risk of poverty, and their parents might be dealing with the system and stuff like that, to lower the percentages that we're seeing that have created this school to prison pipeline?
Mhm. Well, first, I will share just a couple of um, thoughts, but then I want to share about a friend of mine. So just a couple of quick thoughts. The school to prison pipeline is as much a manifestation of our spirit of institutionalized vengeance as the death penalty is. That there are just some kids that are destined to spend their lives in prison. And we can't really interfere with destiny or fate. These are kids, who, hey, it's sad. It's sad. Maybe it's not through no fault of their own, but that they just got dealt a lousy hand by the universe, and they're just going to. These are the dregs, man. These are they're bad eggs, and it is what it is. I mean, that's kind of the attitude that people take who are not willing to try to disrupt the school to prison pipeline. That apathy and that resignation that there are some kids who are somehow bad. Um, it's of course false, but if you're not wanting to do anything about the problem, you'll believe a lie. And so I think it's very important for us to share stories of people who were in the school to prison pipeline and demonstrate, that no, you don't just throw a kid away in whether it's in juvenile court, or if they get transferred to adult court, you don't give them a draconian sentence, that we need to be willing to interrupt that. You can't just put another school resource officer into a school and have a zero tolerance policy. Again, if we could punish our way out of these issues, it would have worked by now. We've been trying that for a long time, and it does not work. It exacerbates issues. So I think learning from history, recognizing that if we continue to adopt punitive policies within schools, that we're not interrupting the school to prison pipeline, and our communities are paying the price for that. What I want to say though is that, and I kind of alluded to it already, the experts in this stuff are directly impacted people. And so at every turn, we need to be elevating the voices, the expertise, the experience of people who have served lengthy sentences for crimes they committed as children, or who entered the juvenile system and never were able to get out of that pipeline. Because I have learned so much just from listening to them articulate what would have made a difference in their circumstances. So my friend Eric Alexander, whom I work with at the CFSY, while he was still locked up, he drafted youth programs for the Metro Nashville Public School and the YMCA. He was like, I remember what I was like as a 15, 16, 17-year-old kid. I remember what I needed. I might not have known at the time that I needed it, but now I know what I needed. And so he wrote these programs, and when he got out, he shopped them around, and he did become a vendor in the public school system. And the YMCA changed its hiring policy because he had a felony record, and they had a no felon policy at the time. They changed it in order to hire Eric to be an employee working with at-risk youth. So again, we know who the experts are. If we'll go to them, that's part of the benefit of giving people second chances. I can't run a violence intervention program in Philadelphia. I wouldn't know where to start. But Donnell Drinks, who served 27 years for a crime he committed in Philadelphia, he knows how to do that. He's got the credibility to be out on the streets at 2 a.m., interrupting potentially bad situations. So I think, recognizing they are our experts and listening to what they have to say is really of paramount importance for disrupting the school to prison pipeline.
We are out of time. I think there's a class in here at 1 o'clock. So I want to thank you for your time. I love the way that you talk about the Centoy Brown story. That's how I learned about you and the campaign. It's very moving. So thank you. We appreciate it. I'm gonna and Thanks so much. We appreciate your time.
I appreciate the invitation. It's good to be with you.
Thank you. Have a good rest of your day.
Y'all as well.